Calling the meeting to order. We're going to start with Senate Bill 2417. As many of you remember, a number of years ago, about 3 years ago, we brought before this body one of the first name, image, and likeness bills in the country. And I remember it very well because at the well, I told you all that this would be a bill that we revisited multiple times and that you would see us back again on that. And such is the case with the ever evolving law and process that we're doing. The bill before you today is a bill that we're very excited about. Missouri made some massive changes in their legislation last year. South Carolina is following right now to suit. And you can see if you follow their legislation, they've been doing this. But what this bill does, it essentially allows the universities and the colleges to better help these student athletes. So the wall that basically was driven that they really could provide little assistance or little help to these students and being able to procure and see these contracts and all of that, this is going to further help the universities be able to help the students. So it's a very good bill. It's one that is supported. The legislation that you have before you is one that you have the attorney here from Ole Miss who helped draft this. He also worked very strongly with Mississippi State's attorney. And we have Southern who has reviewed it, and we have Jackson State also in the room, and everybody has really been looking at this as to what's the best thing for our athletes. And so we're excited to be able to kind of come through that today. I'm going to walk you through the bill because it's significantly changed from the past. And David is here to answer questions about this. That you can really talk about this. So what we did is Section 1 simply really changes the definitions that we have in the bill. Section 2 revises, Section 1 revises the name of the bill. Section 2 revises the definitions of compensation, publicity rights, student athlete, and third party. More importantly, it provides that a student athlete who's an individual who's enrolled in or has signed a national letter of intent or other written agreement to enroll at the university or is being recruited by the institution. This section also revises the term publicity rights to encompass now name, image, and likeness. So that's where the terminology is a little bit different. Section 3 authorizes the institution or any of their employees directly or through an agreement with a third party to identify, create, solicit, facilitate, negotiate, support, assist, or otherwise enable opportunities for student athlete to earn or attempt to earn compensation for their use of their publicity rights. The Act authorizes the institutions to discuss with the student athlete the potential to earn compensation for their publicity rights if they attend the university. Additionally, it puts some parameters on the university. For instance, like they can't receive compensation for helping that student. Anyway, subsection 2 and 3 provides that a third party can compensate a student athlete for using their publicity rights for an athletic event, the student's post-secondary institution, and intercollegiate programs. Also says that the post-secondary educational institution or officer, trustee, or employees of that institution may compensate the student for their use of their publicity rights to the extent consistent with the rules of national associations, conferences, or other organizations. Before any agreement or for compensation is entered into, the post-secondary institution may require the student athlete to disclose the terms to a designated official of the institution. We later on in the bill have made those private agreements that are not subject to the Public Records Act. Section 4 deletes existing language in the statute. While many of the provisions are very similar to existing law we've changed some of the language because we changed some of the definitions of that. The student athletes' publicity rights may not extend beyond their participation in the sport at the institution. Post-secondary institutions, just like we had in prior language, can impose reasonable limitations on participation dates and times. Nothing in this bill restricts an institution for exercising for its sole discretion to control the authorized use of its marks or logos or to determine a student's athlete's apparel, gear, or other wearable items while they're participating in those athletic activities at the university. A student athlete cannot receive compensation for using their publicity rights in a way that includes registered or licensed marks, logos, or designs of a post-secondary institution unless they have written permission. If permission is granted, the institution itself may be compensated for those rights. The institution may prohibit the athlete from wearing any clothing, shoes, or gear with the name, logo, or insignia of any party while participating in an intercollegiate athletics program. And the third party cannot enter into any publicity rights agreement with the student athlete or compensate them if it conflicts with the standards, rules, and regulations or requirements of the post-secondary educational institution. Student athletes enrolled in a post-secondary educational institution are prohibited from entering into publicity rights agreements or receiving compensation for endorsement or promotion of brands that are considered inconsistent with the institution's values or missions, or negatively impacts the institution or its athletic programs, including brands involving gambling, sports betting, controlled substances, marijuana, tobacco, alternative or electronic nicotine delivery systems, alcohol, adult entertainment, or any other brand. Also make sure that we state in here, the bill also provides that nothing in this chapter shall be construed to qualify a student athlete as an employee of that institution. We amend existing law to provide that no post-secondary educational institution or any officer, trustee, or employee of the post-secondary educational institution shall be subject to a claim of damages related for their adoption, implementation, or enforcement of the contract rules and regulations. Subsection 2 prohibits national association conferences or any other group with authority over the sport from enforcing a contract, term, rule, or bylaw that penalizes an institution, their athletic program, or student athlete from performing, participating in, or allowing other activity related to that, preventing the institution from with third-party entity to act on the student's behalf or to identify, create, solicit, facilitate, or negotiate. And also penalize an institution because an individual or entity whose purpose includes supporting and benefiting the post-secondary institution or its intercollegiate athletic programs violates any contract, term, rule, regulation, or standard, bylaw, guidance, or any other requirement that is in conflict with this. And finally, in subsection 3, we prohibit a person or entity, regardless of residence, from giving or promising to give compensation for the use of publicity rights of a student athlete that is currently enrolled in or has signed a national letter of intent or other written agreement to enroll in a post-secondary educational institution within the state of Mississippi with the purpose of recruiting or inducing the student athlete to enroll at another post-secondary educational institution. We also amend the Uniform Athletic Agents Act, and we have put in that we're kind of following the lead of South Carolina, who's put some provisions in there with this that provide that an athletic contract compensation shall not exceed 20% of the agency contract. The rest of the bill simply brings forth the code sections of the Uniform Athletic Agents Act. That is a very long explanation of this. Do we have questions? Yes, Senator.
Thank you, Madam Chair. As far as the NC2A, are there's nothing that would, as far an agent, you know, there are specific restriction as far as an agent is concerned. So that's the student athlete is also protected in this from the agent.
Yes.
Make sure that their eligibility is not impacted as a result of working with an agent.
Yes. So if you'll look at the whole second part of the bill is the Uniform Athletic Agents Act, and it brings forth all those code sections that protect the student athlete in those practices. We've simply added in provision here to make sure that we don't have any predatory practices of them asking for an unreasonable compensation fee for helping negotiate that on the behalf of the students of an agent. And so we've just limited that agency contract to 20%. So we brought forth all those things that you see that we've passed already in code section.
Thank you, Madam Chair.
Okay. Additional questions, Senator Hobson?
Thank you, Madam Chair. Refer you to line 155, where it says that the agreement for use of student athletes' publicity rights, which is formed after the student athlete has announced an intention to attend. Is that correct? When they've announced their intention?
Yes, sir.
So if I commit to an institution, but I haven't signed the national letter of intent, the publicity rights can start at that point. Is that what that's saying?
Yes, sir. That is what that is saying. David, do you want to talk about that particular provision?
I can. So high school students sign national letters of intent. Students in the transfer portal don't sign national letters of intent. Sometimes they'll sign financial aid agreements or other things, but it was the opportunity for once somebody has indicated they're going to come to a school that they could enter into the deals. It's to prevent
Seems like this would create some inducement, David. Well, let me separate this. This may be a code section. I don't have the entire code in front of me. This 3797-107 could be dealing with the transfer type players or student athletes instead of high school students, but it just seems odd to me that once, I mean, I see this all the time now, that student athletes, high school kids, if you will, high school young adults will say, I'm committing to go to XYZ University. And 3 weeks later, they drop that commitment and they commit to another school. But so once they announce that first intention to go to a school, the publicity rights kick in. Is that what that's saying?
I don't have to, but it would allow discussions with either enrolled student athletes, student athlete who has signed the national letter of intent or other document like the financial agreement, or a student athlete.
Maybe I'm missing a piece here, David. It just I feel like there'd be an awful lot of inducement if once I announce the intention, before I sign a national letter of intent, I could qualify for the publicity rights, get that process started. Is that what we're intending to do?
Yeah. I don't know if anybody's been following the litigation in Tennessee against the NCAA, but the NCAA has been enjoined by a federal court in Tennessee from preventing electives from talking with prospective student athletes about what kind of NIL.
So just again, maybe I'm beating the dead horse here, but teasing this out a little bit more. If I commit, I guess I'm assuming that if a collective or another group starts negotiating with this student athlete and they go and talk to him or her, and they once they commit, then they sign them up. But I trust that they would have an agreement that wouldn't pay them until they've actually enrolled at the university or signed a national letter of intent, at least, not just announcing the intention. Because this says announce the intention as opposed to signing a national letter of intent.
Which line are you?
Oh, it's 155. And maybe I'm reading this wrong. Maybe it's out of context, but it shocked me when I saw announcing the intention. I think about how many student athletes now commit, and then 3 weeks later they've decommitted and they recommit to another institution.
Yeah, and just the intent of actually this section is really the provisions that are in line 158. Just to say that the NIL deals cannot extend beyond student athletes. So it's not this isn't the provision that's really intended to enter into the contract. Really to talk about when that NIL deal is.
Yeah, I read that part, and that makes sense that it can only go for the period of time that they participate in the sport. But I guess you could pay someone and get duped. I suppose they could take the money and then, or do they have to participate to actually, or can they start getting the money before they participate at the institution?
They can enter into NIL deals. If again, if they're enrolled or if they're being recruited. And I think it's important people know, I mean, we're not just talking about collectives. So there's some kids who have deals with different companies that they want to sponsor them. Going to I've seen our quarterback.
Okay, thank you, Madam Chair.
It's a changing world and a changing.
It is.
environment with NILs. And so I will say this, Senator Hobson, this language is very similar to Missouri and what South Carolina is looking at as well right now. So it's very similar language. So Senator Sparks.
Thank you, Madam Chair. And I know y'all have put a tremendous amount of time into this, and it is evolving. But going back to what Chairman Hobson was saying, you also look at a student athlete is now defined as someone who has signed a national letter of intent. So we are opening it up to people who are not enrolled, who are below the age of 18 for compensation, correct?
Go ahead.
Actually, this definition of student athlete is more restrictive than it used to be. So the old definition.
Yes, go ahead.
So the old definition of student athlete actually had anybody who would at some time in the future be eligible to play intercollegiate. This one is folks who are either signed a national letter.
And there, that goes back to 155 is being recruited. I go back to the old Todd Marinovich story, who was a high school phenom out of California, and had NIL been available, he would have got it in the 8th grade. Is that where we're headed? Because if someone has verbally announced, and we've seen some of these, announcements of juniors, sophomores, et cetera, in high school, I'm just curious, from that standpoint, is there any age limitation?
Yeah, I mean, if that needs to be tightened up, I'm not opposed to it. We were just trying to make sure that we would be discussions with high school kids who are making choices, as well as kids in the transfer portal who are making decisions. So, I mean, having more eyes on something. Recruited by an institution. I mean, in theory, the language is more restrictive than the current definition of student athlete, but I understand your point.
And I don't want to restrict our institutions from being competitive across the country either. So there's last question on 269, where we're talking about the agent's contract limitation. Is there any language that prevents some agent or agency from fronting money to a prospective client? Because that seemed to be what got people in trouble for years and years with the NCAA, was money that comes to you pre-contract. So is there any consideration about loans made by these agents that would then be repaid?
There is not a direct prohibition in here. If I'm, there's not a direct prohibition in here. One of the things too is, remember, when we're talking about these agreements with this, we are talking about, it is more of a, they're promoting their name, image, likeness, they're promoting a product, they're promoting this. And most of the time, you're going to have to see some level of performance that's going to go with this. So just kind of be cognizant and aware of this. Additionally, too, We are not following the Missouri model of legislation, which actually dipped this down into the high school arena, because our High School Athletics Association here in this state does prohibit that through their rules and regulations right now. So we have not followed Missouri's in that. So this is really not intended to try to look at that high school athlete that you talked about earlier.
Thank you, Madam Chair.
Additional questions?
Motion.
Senator Delano, you have a motion?
Motion to adopt committee sub.
All in favor? Any opposed? All right, the motion passes. Do I have another motion?
Title sufficient to pass committee sub.
All those in favor? Oh, second. All those in favor? Any opposed? All right, the motion carries. All right, next on our agenda, Senator Delano, you're up with.
Thank you, Madam Chair. We have two bills here that were before us today. First bill is Senate Bill 2723. It deals with the HELP grant. Both these bills deal with financial aid. The HELP grant is designed to help. What we need to do is to remove the HELP core curriculum requirements, align the requirements related to the definition of family and determination of need to the federal rules, and then to remove some outdated language. This bill and this next bill that we're working on are still works in progress. This is a bill that we needed to keep alive, keep moving through the process. But the intent here is to align some of the requirements, or well, maybe I should say it this way, that the core requirements for the HELP has created, the way that it is now, has created a laborious process for our high school counselors to follow, when in reality, most of these guidelines are the same guidelines that are requirements for acceptance into a college or community college. So if we remove the core curriculum requirements, again, those will be picked up by the community college or the IHL. So we wanted to remove that to help reduce some of the burden on the high school counselors. The second part of it is to realign the requirements, the definition for family and determination of need with the federal rules. And you'll see that in section 1.7. And again, that just aligns it so that it's more consistent and it follows the free application federal student aid guidelines for household verification and household size. And then the last part of it is to remove some outdated language in section 1.4 and 6.7 that has references to old language from 1996. That's an explanation of that bill. And Madam Chair, I think it would be appropriate if we entertained a motion to amend this to add a repealer bill in it.
All right, you've heard Senator Delano's motion to add a reverse repealer in here. Is there any opposition? Or is all in favor? Any opposition? All right, motion carries.
And then the motion would be title sufficient to pass committee sub.
All right, move to adopt. Sorry. We have a motion to adopt the committee sub. All in favor? Any opposed? All right, the ayes have it.
Great. Thank you, Madam Chair. Next bill is Senate Bill 2724. And this is something that there's a handout that's in our packet that's like a little colored thing. Did this primarily for Senator Carter, but it's easier to follow this way to show some of the redesign proposals. This is our major piece that we do for a lot of Mississippians. There's been some discussions. This bill has not been, or this financial aid package has not been changed since 1995. It's served over 750,000 Mississippians over the years. And there's been a lot of discussion with the Office of Financial Aid and the IHLs on how to improve this over the years. This is something we did discuss last year, didn't make it all the way through the process. But again, we came back with some additional revisions. You'll see in slide 2, which is at the bottom of page 1, it shows how we've increased the dollar amounts for people in lower incomes from 0 to 50% of the median income. And then we have another award for another classification for 51 to 100% of area median income. And that is something new. If you make over 100% of the median income, then the amounts would stay the same and there's no change to that. The second page shows a little chart that shows what the differences would be and the total impacts would be. And as it stands right now, there's new redesign would have an incremental cost for the state of $31 million. It would provide additional recipients to about 37,800. And that would also include, and I should have stated earlier that we're removing a Pell exclusion for this award. We're making sure that there is maintaining no income cap, and that we're eliminating some of the part-time student or we're providing it for part-time students. As it was before, if you were coming out of high school, you were eligible for this grant, but if you did not go to a post-secondary school or didn't go to a community college, and then you sat out for a little while, you were not able to come back and get this grant. We're providing some provisions to allow that, and that's where part of this 37,000 new students come into it. Another part of this proposed legislation is what has been called the last dollar, or the community college program. This is the Mississippi Promise program. And what we're looking at doing with that is opening this up to make sure that college students have an opportunity to have their community college dollars paid for. For us to provide that, it would cost an additional average of anywhere, and the numbers are we're still trying to ascertain exactly what this is going to look like, but it's going to be between $7.5 million to about $10 million a year for us to be able to provide this last dollar program to students. Which we don't believe that there's going to be any new students that are above these total in this middle column that says 63,600. We don't believe there's going to be any change in that number because this money only goes to people who are already going to college and that are already in the program. So it's just an additional dollar amount. I think it'd be safe to say that we're not to exceed $10 million. That's an explanation of the bill. Again, there's a lot of things that we have to do. We obviously have to go through the appropriations component of this. There's some additional work that we're doing on it, but I would like to add a reverse repealer in this bill as well, Madam Chair. But I'll yield for any questions at this time.
Questions for Senator Delano?
Senator Hobson.
Thank you, Madam Chair. Looking at chart 3, you've told us what the costs were for the MTAG increases and the community college, roughly with the community college or the cap on the community college increase. We just passed the HELP bill a few minutes ago, obviously with the reverse repealer. Do you have a dollar figure on the increase for that one?
I don't have the dollar amount for that right now. There's still some work that's being done. And at the very end, I believe it's in the bill itself that it says we have a fiscal note that's been requested on it, but I don't have the information on it. That's another reason why we're trying to just keep this going and keep it alive for at this time.
Thank you.
Additional questions? Senator Delano, I have a motion for an amendment.
Yeah, I'd like to make an amendment to add the reverse repealer to this bill.
Okay. Senator Delano has made an amendment to add a reverse repealer. Do I have a second? Second. All those in favor? Any opposed? All right.
Motion be title sufficient, due pass committee sub.
Okay, we have a motion for title sufficient, due pass committee sub. All those in favor? Any opposed? All right, and then you have a motion for the final passage.
That's it.
Okay.
Is it? We already did.
What? Okay, all right. All right, next we have the University System Efficiency Task Force. This is a piece of legislation. We had hearings earlier this year where we were looking at one of the things that we looked at, that we had a lot of data and information presented on, was the enrollment cliff that we're seeing across the country, and how that would impact our Mississippi universities. Additionally, that enrollment cliff, and we've seen declining enrollments at some of our universities. We've seen increasing enrollments at some of our universities. But this would give us an opportunity to look at this over the summer with the task force. The task force would be comprised of the chairman of the Universities and Colleges Committee, the chairman of the Appropriations Committees in the House and the Senate, the chairman of the Finance Committee in the Senate, Ways and Means in the House. We also would have the director of the University Research Center, and we would have one designee appointed by the governor that represents the regional institutions. We would have another designee appointed by the governor that represents our 3 public historical Black universities in Mississippi. And then we would have another individual that would be appointed by the lieutenant governor that represents our 4 public research institutions. One of the things that the task force should meet within 45 days of the effective date of this bill. We would look at the current enrollment formula that was brought forth that they discussed in that hearing. We also would look at the physical plant of what's going on with many of the buildings and across the state, and the needs in relation to that with that enrollment cliff, because there's some great needs across that. We also would collect and analyze any publicly available data and statistics into enrollment, graduation rates, particular with a focus on rates of Mississippi residents and all other data related to that. We would also examine the existing and developing plans and the public universities to address those demographic shifts and enrollment declines. And we would evaluate the strategies that are being used and the efficiency and effectiveness of those strategies. And then final, as a catch-all, review any matters related to that. We would also be requesting the assistance of the Mississippi Institutes of Higher Learning and other entities that would do this. We also would be requesting the assistance of the peer committee to help us provide the clerical support of that. That is a brief explanation of the bill. Do I have any questions about the bill? Senator.
Thank you, Madam Chair. I have a couple of questions.
Okay.
And I think, the internet, the email thread that we've had of late regarding the closing of institutions, and and I think when this bill came out, there were several questions that were placed regarding the possibility of association of that. And I just wondered if you could just basically clear some of those up for me.
Well, first of all, this is not the bill that there was lots of questions about. There was another bill that had that we are not bringing up here today. You see, it's not on the agenda today, that would ask the College Board and direct them to look at closing 3 universities. This is not what this bill does. This bill looks at really what is going on at our colleges and universities as they are right now. What we need to do in regard to that enrollment cliff that we see that is coming, and we need to be proactive in helping our universities and colleges manage this. It's very important for us in looking at allocation of resources and funds that we know what the direction that our universities are headed. I also want to know how they are planning for this enrollment cliff and the plans that they have to try to increase enrollment, what strategies they're using for that. I am not on that appropriations subcommittee, but a few of them tried to kind of mention some of that in their appropriations subcommittee. So this bill is about us taking a look, which we haven't done in a while as the Senate and as the legislature, really taking a real look at what is going on with our universities and colleges, looking at the metrics of them, and how do we best plan and how do we most effectively appropriate monies so that we can help our universities and colleges succeed and help our students and the workforce of Mississippi.
Okay, I mean, certainly I understand all of that. I guess my second question would be once the task force finishes its charge, obviously there are going to be some deficiencies, especially as it relates to the historically Black colleges and universities in terms of a physical plant and so forth. Do you anticipate that including funding recommendations to clear up some of those?
I hate to go ahead and direct what exactly those findings would be, but I think, Senator, you are looking at, I was in the committee that goes around and looks at our state universities, our public properties and all that, that's summer committee. And all of our universities have needs very much so related to the physical plants that are there. We have in a number of our college campuses, we have dorms that are sitting because they're not habitable. And so I think that this committee will be looking at all of that, whether it be with our historically Black colleges and universities or our other universities as well, because I think there's a lot of deficiencies, and we're going to be looking to see how most effectively to help our universities and help our students, and then therefore help our workforce.
Okay, I mean, there's been a lot of conversation, and
Yes, there's been a lot of misinformation that has been out in the public for a number of days, and to one of our colleagues here, I'm so sorry at the misinformation that has been out, because it's a little bit ironic to me that this bill and this legislation has been so misquoted when we're talking about universities and colleges. So clearly we might have some literacy issues that we need to look at because of that, because that is what his legislation said and what it was purported to say were entirely two different things. So do I have any other questions? I think this could be a really proactive thing. I look forward to working with the College Board on this. Senator Polk.
Just for clarification and to end the conversation, I'm assuming that this bill will, if we pass, will go forward, and your intention is not to bring the bill that I introduced out. Is that correct?
Yes, Senator Pope, that is correct.
Please, everyone, get that message out. The chair has killed my bill. We're going to study it. And that way I can sleep tonight.
You can sleep tonight.
Thank you, Madam Chair.
We have a motion. Do I have any additional questions though? We have a motion. Motion is titled sufficient. Do you pass? All in favor? Any opposed? All right. Senator Blackman is not here. Oh, you are. I'm so sorry. You're back in the back. So
What you doing there?
yeah. All right, Senator Blackman, you are up. And we have made one change on this. So to make sure that it's consistent with the first bill that we passed, so that you haven't seen yet. So this is a little bit of a stretch for colleges and universities. This is the Mississippians' Right to Name, Likeness, and Voice Act. Senator Blackman has done a good bit of research on this bill. It is a bill that is passing through the legislatures in other states. And so I'm going to ask you to explain your bill, Senator.
Thank you, Madam Chair. This bill was brought to my attention by members of the Recording Academy and representatives for Bobby Rush. I believe he paid the committee a visit sometime last week. They brought it to my attention that in Mississippi, there's no statutory right, a property right to your own name, image, and voice. So I started looking at it, and I believe in 1951, the Supreme Court recognized the common law right to privacy. Then in 76, they recognized the intentional tort of invasion of privacy. And then in 86, they recognized the tort of appropriation of your identity without consent. And I since '86, I couldn't find any cases where there was another right established or recognized by the Supreme Court. Is kind of left at a misappropriation of your identity without consent. So we looked at other states. There's about 19 states that recognize a property right in your identity, but none that have looked at how artificial intelligence plays into that in these days. There is a bill in Tennessee that does address that. They call it the Elvis Act. It's passed both of their committees on the House and Senate. I guess that's what they call them up there. I'm not sure. But we looked at their legislation and then kind of looked at the different states that have property rights and came up with this bill to try to avoid some of the issues that they were coming in front of Tennessee. So a brief explanation of the bill is Section 1 would call this the Mississippians' Right to Name, Likeness, and Voice Act. Section 2 goes through the different definitions that are used in the bill. And then when you get to Section 3, it creates a property right in an individual's name, likeness, and voice. And those property rights are freely transferable by an individual during their lifetime in whole or in part, and it would not expire upon the person's death. They're able to transfer to their executors, their heirs, their transferees, devisees. And following a person's death, that it wouldn't expire until after 10 years. And then someone that's trying to use it would have to show that following those 10 years, there was a 2-year period where no one commercially used it. And then they would be able, that would overcome that. Looked at, there's one in Indiana where they tried to give 100 years, but the federal court over there came back and then diluted that on down. And the only way for you to transfer those rights, you'd have to be represented by counsel in that transaction. If you're over the age of 18 and it has to be in writing. If you're under the age of 18, it would have to come from approval of a court over the deal, or if the terms of the agreement are governed by a collective bargaining agreement, since there are some performers who are under the age of 18 who enter into those type of unions and guilds and things of that nature. And then Section 4 goes through the different liabilities, which is if someone without their consent, if someone were to use your name, image, or voice, then you would be able to go to the courts for redress on those actions. And the only way they're liable is if they do it with knowledge that it was not authorized. So someone couldn't be handed or I guess now transmitted audio song that they believe is from Marty Stewart, who was just here. And then they put it on their radio station and they didn't know that Mr. Stewart had not authorized that. They would not be liable. And the violations, if someone is found to have violated that, there's several mechanisms of getting damages. It's the amount that's either the greater of the amounts. It could be $50,000 or the actual damages that you suffered by showing that someone commercially used your name, image, or voice and profited. And that way you'd be able to collect more than the $50,000 if it goes higher than that. And it's not a defense to this to just say to the public, hey, this was not authorized. This is a digital replica of someone's song. That does not work as a defense under this law. And the enforcement can come from the individual whose name, voice, or likeness is being used, whoever the person is contracted with to have the exclusive rights to the same, Or if someone's in the music profession and is under contract with, say, Sony Music Group, then Sony Music Group will be able to bring that action. And then in section 5, this is something that I saw became an issue, is the First Amendment defenses to this. And then section 5 covers the First Amendment defenses that someone may use. And section 6 talks about being able to get injunctive relief, the actual damages, and treble damages if it's shown that they requested consent and you did not give a consent and they still used it anyway. You could get reasonable attorney fees, court costs, or expenses, and also no civil action can come after 4 years where someone has discovered it, or with due diligence, they would have discovered that it had been used. And section 7 states that this doesn't affect any rights that are granted by other statutes, and that it shall be severable. And that's a brief explanation of the bill.
Do I have questions? Senator Polk.
Thank you, Madam Chair. Senator, in section 6, I believe it was, you said that after 4 years, you cannot use this bill, use this law. I mean, is that correct?
It's after 4 years of, if you have discovered it and you waited longer than 4 years, or if with reasonable diligence, you could have discovered it in 4 years, like the song has been playing on every radio station or airwaves for 2 straight years, and there's a possibility that you should have heard it or known, or someone could have told you that, hey, this song was, or this image has been being used. It's just to limit endless liability.
My question also would be, in civil law, aren't most lawsuits at the point where after 3 years, you can't claim that?
That's personal injury, is
Okay.
3 years.
Why are we doing a different number here? Why wouldn't 3 years fit this clause?
3 years could. I'm not opposed to the amendment, but I just know 3 years in personal injury. I mean, medical mal was 1 year. I'd like medical mal to be more than
Okay.
1
But
year.
this is longer than either of those two.
Yes.
All right, thank you.
Senator Sparks.
Thank you, Madam Chair. In lines 84 through 93, when we talked about the period of time, I understood it was 10 years that you could, if you had designated this right to use to someone, that there's a 10-year period. And then there's this 2-year period of non-use. Assuming something does not fall into the non-use, that it is perpetually used, does that extend?
Yes, it has to be a 2-year period. You have to show that it has not been used at all for 2 years. It's essentially 12 years after somebody's death. 10 years following their death, it would expire. And then you have to show that for 2 years following that, it was never used. If any one of their heirs uses it at all, that extends it and
Okay.
continue to extend it.
And the reason I asked that, and I know you mentioned a lot about songs and music that we hear, but I would say between James Earl Jones and Morgan Freeman, that's 2 of the most recognized voices in this country. So for their voice usage for the future, one day when it's AI generated, this would protect that right, that those individuals could transact on that right, or their heirs to protect it, because that belongs to them. Is that
That's correct.
Okay. And then the last thing would be for those who operate in the field of impressionism, does this in any way impact their ability to perform impression acts?
No, it wouldn't. That's part of the First Amendment protection.
Okay, thank you.
Additional questions? Okay, I'm going to offer an amendment at this time that we, if you will go to lines 218, it is presented in your committee sub. And if you'll start in the middle of that, it says nothing in this act shall apply to student athletes within the statutory framework of sections 37, 97, 101, provided that when any individual ceases to be a student athlete at a athletics program, such individual shall be availed of the provision of this act. So this is making sure that the provision that we just passed within the first piece of legislation would not have any conflict with this piece of legislation. Are there any questions on that? So moved. All right, all in favor? Any opposed? All right. Senator Blackman, do you have a motion to adopt the committee substitute in lieu of the original bill?
Yes.
Do I have a second? All those in favor? Any opposed? All right, the motion passes. And do I have another motion for Senator Blackman for title sufficient do pass committee sub? All those in favor? Any opposed? Motion carries. We'll report that out. Please look for, we will do one quick meeting tomorrow. We have one bill left that's been doubly referred. And so we will hopefully fit that in at some point next week. Do I have another motion? I mean, tomorrow. Thank you.